Can you please stand as we welcome the procession into the venue? Thank you. You may be seated.
Good evening, everyone, and welcome to this inaugural lecture of our colleague, Shannon Hoctor. In particular, I would like to acknowledge and welcome here tonight our rector, Professor Wim de Villiers, trustees from our Stellenbosch University Faculty of Law Trust, colleagues from other universities and faculties of law who have joined us tonight, colleagues and friends and students from our own Faculty of Law, as well as SRC Council member representatives. I saw their names on the list as well. And then quite a novel and an honor for us tonight is also a number of foreign dignitaries, including members of cabinet, ambassadors, high commissioners, and leaders in fighting corruption who are all currently attending the Pan-Africa Counter-Corruption Assembly taking place at STIAS. But of course, the honorary guests tonight that I would in particular like to welcome is Professor Shannon Hoctor and his family. I am pleased to welcome Michelle, Shannon's wife, his daughters, Kezia and Ilihana. If I understand correctly, it's one current Māori and hopefully one future Māori. Shannon's father, Mickey Hoctor, as well as his brother Brandon and his wife Diane, also two Māori's alumni. I have to specify this because it's quite clear that Shannon is overwhelmingly outnumbered in this family as far as UCT and Māori affiliations is concerned. Now, colleagues and friends, it is a great pleasure and honor to me to say something more about the person and to introduce you to Professor Hoctor. Professor Shannon Hoctor began his academic journey at UCT, but he also taught at the former University of Port Elizabeth and the University of KwaZulu-Natal, Pietermaritzburg. In all instances, he has designed, introduced, and taught a range of courses, particularly in criminal justice and advanced criminal justice. Professor Hoctor was appointed as a professor in this Faculty of Law in the Department of Public Law in July 2021. It is really impressive to share with you that Professor Hoctor has published more than 122 articles in law journals, 95 book chapters. He has authored 13 books, including 5 edited works, primarily in criminal law and road traffic law. Over and above that, he has also published 70 pieces in non-accredited publications and delivered numerous papers at national and international conferences, along with other papers at seminars and colloquia. Professor Hoctor is a true scholar. He's an encouraging colleague, and he's a responsible academic citizen. He has served as editor-in-chief of the South African Journal of Criminal Justice since 2010, of Fundamenta, a journal of legal history, since 2019, and as assistant editor of Obiter since 2002. That's really something. He has also served as deputy dean of the UKZN School of Law and as academic leader of the Social Legal Studies Unit, Pietermaritzburg. He has served as president of the Southern African Society of Legal Historians since 2017, and he is a member of the Selden Society and Stay Society. On a more personal note, when I asked Professor Hoctor what does he do in his free time, He said that when he's not thinking about criminal law, he likes to read. And yes, you can guess, especially crime fiction. And especially while eating dark chocolate and drinking red wine. That's why he fit in so perfectly with our faculty. In his own words, he's an ever-willing taster for whatever is coming out of the Hoctor kitchen, and he enjoys spending time with his family. That's the person, our colleague Professor Shannon Hoctor. Something about the occasion. An inaugural lecture gives the faculty and Stellenbosch University a platform to recognize the addition of a senior new colleague that has joined our ranks. An inaugural lecture is also an occasion for an individual to showcase their academic journey. And of course, it is a very rare opportunity to share a professional milestone with an audience that includes family, friends, students, and colleagues. Moreover, an inaugural lecture is an opportunity to increase awareness regarding contemporary research issues. And tonight's topic, sharpening the subjective element of criminal liability in South African law, deals with a very current and important issue. I now invite Professor Hoctor to deliver his inaugural lecture.
Many thanks, Nicola, and it's such a pleasure to be here, and I'm very grateful for your presence here with me as I engage in this very special event in the life of an academic, so thank you for sharing with me. The question of individual criminal responsibility is fundamental to the substantive criminal law. The subjective element of criminal liability in South African law has been sharpened by doctrinal development through the cases provoked by the work of J.C. de Wet. And so it's wonderful to be able to deliver this lecture in the J.C. de Wet Lecture Theatre. And as I say, J.C.'s got my back. So my criminal law journey began at UCT under Solly Lehman, apparently one of J.C. de Wet's finest criminal law students, who naturally instilled in me the incontrovertible superiority of J.C.'s theoretical views. I shall first trace the historical development of criminal responsibility in South Africa, highlighting de Wet's definitive contribution, before discussing the current legal position and how the subjective element may be further sharpened. When we talk of a subjective approach to liability, it is simply that it is the perspective of the person accused, of a crime, the accused, that matters. His insight, his estimates, his point of departure, his decision, and not the perspective of anyone else. Bill Stuntz, the Harvard criminal lawyer, has said that as academics, we know less than we claim to know, and we are not as smart as we claim to be. Our theories may be beautiful things to behold, if anything published in a law review may fairly be called a thing of beauty, but they tend to ignore a great deal of messy reality, especially the reality of our own limits. So this too is my own point of departure. And so tonight I confront the vexing plight of the academic. You know the vexing plight of the academic? To simultaneously worry about being interesting, or uninteresting rather, and about being wrong. Okay, so here we go. Allow me to place two scenarios before you. Scenario one. The husband is serially unfaithful to his wife and has rejected their disabled children who require his wife's ongoing attention. The wife is consequently extremely stressed and on medication. One day the husband comes home after having been out the whole day. A friend is visiting the wife who is emotionally overwrought. She suspects that her husband has gone back to his lover after promising her faithfully that the affair was over. The wife provides her husband with food. He asks, "Why are you looking at me?" and gets up from the table to fetch a tape recorder. Some of you may know what that is. He likes to record their arguments. Embarrassed in the presence of her friend, the wife tries to switch off the tape recorder and it falls to the ground. The husband proceeds to violently assault the wife, breaking her nose and knocking out one of her teeth, while splintering others. Her glasses are broken, her nose and mouth are bleeding profusely. The husband declares that he's leaving. The friend tries to clean up the blood. Later she hears shots. After the husband threatened to kill his wife, she picked up his pistol and fired 7 shots at him. So is this murder? Scenario 2. A motorist is stuck behind a slow-moving truck on a single-lane highway. Anyone been there? After a long delay, an opportunity presents itself for the motorist to overtake, but it is on a blind rise. So if the motorist pulls out to overtake, he will not be able to see any possible oncoming traffic until the very last moment. He considers the risk as well as the possibility that it may be a long, frustrating period before the opportunity to overtake arises again. He pulls out, colliding with an oncoming vehicle, and kills the driver of the vehicle. Is this murder? In Packer's extremely influential analysis, the modern criminal justice system is activated by 2 different models: the crime control model and the due process model. The focus of the crime control model is crime prevention. Affirmative of official power, the crime control model values efficiency, speed, finality, results. The focus of the due process model is on protection of human rights. Values of reliability, equality, and the prioritization of means over outcomes characterize the due process model, which asserts limits on official power and how it's exercised. So what should the focus of our criminal justice system be? Crime control or due process? Packer's insight is that a modern system of criminal justice does not subscribe exclusively to any one of these sets of values, but rather consists of a mixture between the two. And so, of course, that creates a tension between these 2 sets of values as they compete for priority and compete with each other for dominance. Both models reflect valid concerns, respectively, the societal demand for effective and efficient crime control, and, on the other hand, the demand that the rights of accused persons are upheld. So how should we balance the respective sets of values in our criminal justice system? And how could we do this optimally in the context of the general principles governing criminal liability? So what are these? Criminal liability requires the performance of a voluntary, unlawful act, an actus reus, contemporaneously with a blameworthy state of mind, mens rea. The onus of proof to establish guilt is proof beyond a reasonable doubt, such that there must be no other possible reasonable explanation except that the accused is guilty as charged, all the requirements for criminal liability having been satisfied. The set of requirements for the unlawful act and the blameworthy state of mind are distinct and crucially are differently assessed by the court. So the test for the unlawful act requirement is an entirely objective, diagnostic, ex post facto criterion where no reference is made to the state of mind of the accused. What of the test for a blameworthy state of mind? First, the question arises whether the accused had the capacity to commit a crime at the time of acting. If this is established, it must be ascertained whether the accused had the necessary subjective intention to commit the crime. So just to clarify negligence, the absence of a state of mind will not be discussed. While negligence is a form of fault used for culpable homicide and some statutory offences, intention is required for all the other common law crimes and for the more serious breaches of the law. Moreover, even a negligence conviction must be preceded by a finding of subjective criminal capacity. So while negligence is acknowledged as a necessary objective intruder as a form of criminal fault, the focus for this lecture is on the state of mind, capacity and intention, which are all subjectively assessed in South African law. Now I make that point because it was not always so. In the first half of the 20th century, intention was frequently objectively assessed. The objective test neglects the accused's actual state of mind in inquiring whether a reasonable person would have contemplated the harm arising. The crucial question is thus not whether the accused actually contemplated the harm, as per the subjective test, but whether the accused ought to have done so in the circumstances. It seems that the primary reason for the acceptance of the objective test for intention was the adoption from English law of the presumption that a person intends the natural and probable consequences of his acts. Now, the principal objection to the so-called presumption is precisely that it brings about an objective assessment of a subjective notion, intention. The danger of using an objective test to ascertain subjective blameworthiness, where capital punishment was still part of South African sentencing practice, is clear. A person could face execution although he never subjectively intended the harm caused. Just as the objective test approach to intention developed through the case law, so too did the antithetical subjective approach. This opposing development derived from academic work done right here by J.C. de Wet. The publication in 1949 of the first edition of de Wet and Swanepoel's Strafrecht, with de Wet contributing the general principle of liability section, was a cathartic event for South African criminal law. Prior to Strafrecht, criminal law scholarship in South Africa was governed by Gardner and Lansdowne's work of gentle accretion of case law, a practitioner's tome, first published in 1917 and which had just seen its fifth edition in 1948. Whereas Gardner and Lansdowne apologized in the first edition of their work for the possible error of devoting too much time to elementary principles, de Wet brought an unprecedented laser focus on the principles of South African criminal law, informed by Roman Dutch, and contemporary continental European legal systems. Outspoken and intolerant of sloppy judicial reasoning, de Wet raised hackles with his scathing criticism. His genius could not be denied, however, and the study of criminal law theory as a rigorous doctrinal endeavor, characterized by a principled and systematic approach to liability, took root in South Africa. Inexorably, graduates who had been exposed to Strafrecht found their way into practice, and within a generation, the dogmatic transition from a pragmatic approach, dominant in the English legal tradition, to a principle-based approach founded on Romano-Germanic civil law sources was complete. To be clear, de Wet's insights were all accepted. In some respects, he was, perhaps surprisingly, and certainly inconsistently, less inclined to subjectivism than one would have expected. By 1985, when the fourth edition of Strafrecht was published, the vigor of his analysis had faded. But by then, the work had been done, and his legacy was secure. Through judicial acceptance of de Wet's key points of departure, South African criminal law had changed irrevocably. Apart from the construction of the doctrinal edifice of criminal liability, the most significant change incorporated in the shift to a principled approach to liability was the adoption of the subjective psychological approach underlying the notion of blameworthiness, described by Snyman as the psychological relationship between the accused and the act or ensuing result. The transition from objectivity to subjectivity in criminal responsibility intersected with a dramatic event in South African history, the assassination of Prime Minister Verwoerd in Parliament by Stefendis on the 6th of September 1966. Stefendis was held incompetent to stand trial on grounds of mental illness. This, not surprisingly, prompted a commission of inquiry to be established under the chairmanship of Judge Rumpf to examine the question of criminal responsibility flowing from mental illness. The model for criminal responsibility formulated by the commission in 1967 ultimately found its way into legislation. And thus, the notion of toerekeningsvatbaarheid, or criminal capacity, was foregrounded in South African law. The Commission referred liberally to the work of a Dutch psychiatrist, Wiersma, in his book Over toerekeningsvatbaarheid, which had been highly recommended by de Wet in the detailed discussion of criminal capacity in the first edition of Strafrecht in 1949. It seems difficult to overstate de Wet's influence in this regard. Previously, the criminal mind was defined in terms of intention, both in the case law and the leading contemporary text, Gardner and Lansdowne. Following Strafrecht's publication, the acceptance of toerekeningsvatbaarheid as integral to the inquiry into subjective guilt was simply gradually accepted, invariably accompanied by a reference to Strafrecht. Along with the Rumpf report, the 1967 Appellate Division case of Maschlinzer confirmed that capacity was part of the inquiry into criminal responsibility. De Wet had been saying this for 20 years. Maschlinzer dealt with mental illness. Section 78 of the 1977 Criminal Procedure Act, based on the Rumpf Commission report, is, as amended, entitled Mental Illness or Intellectual Disability and Criminal Responsibility, and provides that criminal responsibility is lacking where, as a result of pathological incapacity, that is, incapacity caused by mental illness or intellectual disability, a person lacks the capacity to either appreciate the wrongfulness of his act or omission, or to act in accordance with such appreciation, lacks responsibility. Soon after this legislative formulation of the test for capacity, the courts extended the application of this test from mental illness to non-pathological incapacity, where the cause of the incapacity is not mental illness. And this, of course, accords with principle. A consistently subjective approach requires that any factor which negates or eliminates the presence of capacity should result in an acquittal. This logic was applied in the 1981 Appellate Division case of Rectoral, perhaps the most important case in the genesis of the defense of non-pathological incapacity. Overruling previous policy-based authority, the court applied a principled approach, holding that voluntary intoxication at the time of the commission of the harm could exclude liability by negating any of the following elements of criminal liability: the voluntary act requirement, the criminal capacity requirement, and for appropriate crimes requiring intention, the element of intention. Consistent with the Rectoral approach, the equally contentious area of provocation or emotional stress also came to be regarded as founding a full defense of non-pathological incapacity. This was ultimately confirmed in the 1990 Appellate Division case of Veed. Now, you know the facts of Veed, because those are the facts of scenario 1. Was Mrs. Veed convicted? Was it murder? No, said the Appellate Division. She was acquitted on the basis of non-pathological incapacity. And after that, the defense was successfully pleaded on a number of occasions, with courts relying on De Wet both directly in Strafrecht and indirectly via the Rumpf report. This momentous change in the law relating to criminal capacity had been anticipated by developments in the law relating to intention. In South Africa, not only direct intent, or dolus directus, where causing the harm is the accused's purpose, falls within intention, but also dolus eventualis. The social science concept of episodic foresight involves projecting oneself into the future in order to mentally simulate situations and outcomes. Similarly, dolus eventualis involves foreseeing the possibility of the harm occurring and reconciling oneself with the risk of harm. No distinction is drawn between the forms of intent for the purposes of liability. Dolus is dolus is dolus, as Solly Lehman put it. Moreover, dolus eventualis is by far the most important form of intent in practice. Again, it was not always so. De Wet in 1949 in Strafrecht, following some earlier writers, included dolus eventualis in the notion of criminal intent, citing Dutch and German sources, with some distinctly precarious reliance on South African judicial dicta. Within a decade, the Appellate Division was applying the concept of dolus eventualis, holding that a foreseen possibility of harm would suffice for liability based on intention. This broadening of the subjective element was further enhanced when the long-established maxim that ignorance of the law is no excuse was set aside in the landmark case of De Blom in 1977. Again, the implications of a fully subjective approach to criminal intent are clear. There is no unlawful intent if there is a genuine mistake as to the law's content. Liability is based on what the accused actually intended. Clearly, the subjective element in criminal liability in South Africa has already been considerably sharpened, in some respects, even beyond what De Wet contended for. The impact of subjectivism may be demonstrated in the context of common purpose and specific crimes. So the common purpose doctrine provides that where two or more persons, having a common purpose to commit a crime, act together to achieve that purpose, the conduct of each of them in carrying out that purpose is imputed to the others. So each person is responsible for the conduct of others in the group. This doctrine was tainted by its use in cases involving groups committing politically motivated crimes in the 1980s. Yet, it has survived unscathed in the democratic era, being declared constitutional by the Constitutional Court in 2003 in Tebus, and having even been expanded in its recent application. Clearly, it is the common purpose, the common intent between participants to act unlawfully together that does the heavy lifting in theoretical terms here. Each participant is held liable for the harm caused by the group on the basis of her subjective intent to associate in the criminal enterprise, as demonstrated by her conduct. Foregrounding of the subjective element shapes liability in specific crimes too. Just two examples must suffice. Robbery is a much more serious crime than the sum of its parts, which are the crimes of theft and assault. So courts are required to clarify when conduct amounts to robbery and as opposed to theft coupled with assault. And this is typically unproblematic. But difficulty arises in cell phone snatching cases where the violence involved amounts to the use of enough force to grab the cell phone from the grasp of the victim. Recent cases have confirmed that even a cell phone snatcher should be categorized as a robber. Now, objectively assessed, the act of dispossession may not have caused any physical harm, but the subjective element is determinative. Because the accused anticipated resistance in obtaining possession, this transforms the conduct into the much more serious crime of robbery. Similarly, the 2013 Dalinyebo case confirmed that arson includes burning one's own property, wherefore, while seeing that such burning may damage another's property. The accused's intention in acting converts an ostensibly lawful act, destroying one's own property, we can all do that, into an unlawful one. The subjectivization of criminal responsibility has, however, created discomfort and antipathy fueled by policy concerns. Think about this. Is adopting a consistently subjective approach a good idea if it enables those who are intoxicated or angry or mistaken about the law to avoid liability? Is the net of liability then not too narrow? Well, the Supreme Court of Appeal weighed in on whether a defense of non-pathological incapacity based on provocation should exist in the 2002 Edie case. This case is equally applicable to non-pathological incapacity based on emotional stress. Two features of the Edie judgment are the scant attention paid to the development of the non-pathological incapacity defense and the rather selective and sometimes inaccurate citation of previous authority. But the court's focus was not on principle, but on policy. It described its quest as investigating whether the boundaries of the defense have been inappropriately extended, particularly in decisions of the High Court, so as to negatively affect public confidence in the administration of justice. If this was the court's concern, it should simply have stated that the defense was untenable on the basis of the common norms and values of the community. The court, however, sought to reason in the teeth of an authoritative line of cases to the contrary that the principles of law applying in the context of provocation do not allow for a non-pathological incapacity defense. Instead of setting the contrary precedent aside, as the court was surely compelled to do, it sought to reinterpret the findings of the previous case law, thus effectively equating the subjective mens rea inquiry into capacity with the objective inquiry into actus reus inquiry into voluntary conduct. Or perhaps not. The opacity of the judgment has left the law unclear, in itself a sad indictment. De Wet once described the judgment by saying that the court redeneer in cirkels totdat hy uiteindelik heeltemal die klits kwyt is. In other words, the court lost the plot. Such is ED on non-pathological incapacity. Nevertheless, for present purposes, the court's reaction to the defense and its evident need to impose some objective limit on the defense is manifest. Similarly, Snyman has trenchantly criticized the de Blom decision, allowing mistake of law to operate as a defense excluding intention. He's simply aghast that in a crime-ridden society like South Africa, this approach could be followed. Does the psychological approach to criminal responsibility make the net of liability too narrow? Or does it make it too wide? There are concerns. Is it credible for dolus eventualis to include foresight of a very remote possibility? Does such a standard belong in South African law on policy grounds? Does it have any utility in practice? The implications of even faint foresight of the possibility of harm, accompanied by reconciliation with such risk, sufficing for the most serious of crimes, such as murder, is clear. The subjective approach to criminal liability may consequently be criticized for not only not convicting those bearing fault who deserve to be convicted, the drunk, the provoked, the ignorant, but for concomitantly convicting those who shouldn't be convicted, those who happen to have the necessary foresight of the harm occurring but don't really mean it. Why would then would one contend for sharpening the subjective element of liability? Why? Because the question of criminal guilt is absolutely crucial. Not just for the accused herself, but also because the idea of punishing someone who may not be blameworthy flies in the face of not just a moral legal system, but a constitutionally sound legal system. If a legal system is to claim moral authority over its subjects and to respect their autonomy, it should adhere to rule of law principles in its criminal law by ensuring warning, maximum certainty of definition, and upholding subjective requirements for criminal liability. Only by emphasizing choice and predictability can the criminal law show proper respect for the individual as an autonomous, reasoning person. Autonomy, which is closely related to the right to dignity, assumes the basic ability to appreciate reality and distinguish right from wrong, along with the competency to decide how to act, the capability to realize that decision, the internalizing of the fundamental values of the legal system, and a basic commitment to those values by every competent person. It's axiomatic that the individual is the foundation of society and law and must never be treated as an object or instrument. The right to dignity, described as the source of all other personal rights in the Bill of Rights, in the landmark constitutional court case of Makwanyane in 1995, demands that no one should have their rights seriously infringed by the punitive and stigmatizing consequences of a guilty verdict, unless there is a proper basis for such an enactment. The basis for a guilty verdict is blameworthiness. Punishment is only properly inflicted when it is deserved, and desert follows from blameworthiness. Unless the finding of liability is based on the offender's control over his actions, capacity, and choice so to act, intention, which factors underpin blameworthiness, the infringement of the right to dignity that follows conviction is unjustifiable. At the same time, a guilty verdict equally resonates with the right to dignity by treating the offender as a responsible human agent, rendered blameworthy by virtue of the factors of control and choice. These considerations in turn link into the communicative function of law. As Tedros states, in imposing criminal responsibility, the criminal justice system communicates something about the offender and or his act to the offender himself, to criminal justice officials, and to others. Given the negative ramifications for the offender of such communication, such message and its implications are justified only in certain circumstances. Communicating that someone is a criminal is only appropriate if the description is accurate. Therefore, once the accused has committed an unlawful act, objectively assessed, if subject blameworthiness can be established on the basis of factors like control and choice, then liability should follow. Any mitigating consideration should be consigned to sentencing. Where control or choice are absent, liability should not follow irrespective of the reason for the lack of the requisite element of capacity or intention. Milton notes that the developments in South African law, criminal law between 1976 and 1986, which show the preference for the principle-based or psychological approach to liability over the, as he calls it, socially expedient doctrines that denied exculpatory effect to such matters as ignorance of the law or voluntary intoxication, reflects, as he says, characteristic due process of law value. But isn't this the point, some would argue? In apparently slavish deference to the due process model, have we not neglected the very necessary crime control concerns that plague South Africa? My contention is that, in fact, adopting a subjective approach to criminal responsibility maintains the important balance between due process and crime control concerns. Allowing a defense for someone who has voluntarily become intoxicated or has responded to a set of external cues by becoming overwhelmingly angry or emotional raises justifiable policy concerns. But these concerns must be placed in the context of how the courts deal with an incapacity defense. First, the incapacity must be genuine. Whilst the state bears the burden of proving each element of the crime beyond reasonable doubt, an accused who raises an incapacity defense must provide a factual foundation for such claim. On this point, the Edie case is good authority. Courts scrutinize the accused's exculpatory evidence and will not lightly accept it. So although in principle voluntary intoxication or provocation can exclude capacity, this only occurs in exceptional cases, as it should be. Turning to its intention, in the context of homicide, where an accused person has criminal capacity but lacks intention, a culpable homicide verdict for negligent killing is still an alternative. So the floodgates argument that adopting the subjectivist approach will result in a whole lot of guilty going free is not true. Crucially, the psychological approach to criminal responsibility balances its broadening of possible defenses, excluding blameworthiness, by widening the net of liability in respect of intention-based crimes, to include not only direct intent, but also dolus eventualis. Actual subjective foresight of the risk of unlawful harm, accompanied by a persistence in taking such risk, entirely suffices to establish intention. As Alexander and Ferzan state, risk is wholly subjective and epistemic, and not objective and ontic. This is true not only for an individual actor, but also a person who associates with the unlawful conduct of a group in the common purpose scenario. But surely, the argument goes, we cannot have criminal liability based on dolus eventualis for foresight of any possibility of harm arising. Shouldn't liability only follow if there's foresight of a substantial possibility of harm? The underlying policy concerns were noted earlier. But how valid is this argument? It is contended that foresight of less than a substantial possibility of harm is not foresight for the possibilities, for the purposes, I should say, of intention. But to say that foresight is not foresight is simply an abuse of language. Liability should only follow if the accused, having actually foreseen the harm, accepts the possibility into the bargain by continuing in his envisaged course of conduct. But where this is established, there have been convictions even where the possibility of harm foreseen was remote. Although the best way of proving intent is by means of direct evidence, the court rarely has the luxury of a full confession, and so intention has to be proved by a process of inferential reasoning, drawing conclusions from the proven facts of the case. It will be harder to prove foresight of the remote possibility of harm, making a conviction on such grounds, although possible, highly exceptional, and so it should be. So again, adopting a subjectivist approach does not mean the floodgates will open and a whole lot of innocent people will be convicted. But where there is actual subjective foresight of the possibility of harm arising, with which the accused reconciles himself, then the subjective approach to criminal responsibility requires that there be liability. This is brought into sharp focus in the context of murder, where a person foresees the possibility that his proposed course of conduct would result in the ultimate harm of the death of another human being, and he nevertheless takes such risk. His actions clearly evidence the prioritization of his own agenda over the life of another. This is the essence of dolus eventualis: egoism and selfishness, disregard for the rights of others, for the values protected by the law, and for the law itself. Given that the accused acting with dolus eventualis does so with attentiveness to and awareness of the possible risk, and chooses to act despite such foresight, should the degree of foresight prevent him from being found guilty of murder? Surely not. Whatever the context, imposing unjustifiable risks on others' legally protected interests is blameworthy behavior because it displays insufficient concern for others' interests. Again, in applying this logic, there is a nettle to be grasped. Back to scenario 2, the overtaking on a blind rise example. When, for example, road traffic deaths are prosecuted, it is almost always for culpable homicide, for negligent killing. Not only is this because it's easier to prove that the standard of the reasonable person has not been met, but also because there's some policy discomfort in charging motorists with murder. After all, everyone is prone to driving misjudgments. Scenario 2 could be the state versus you, or the state versus me. Anyone ever been tempted to overtake on a blind rise? Don't answer. Could this be murder? It certainly could. The discomfort extends to the use of dolus eventualis along with the broad common purpose doctrine, which already facilitates proof of liability for those accused acting in concert, making a conviction easier and easier. Nonetheless, if the subjective element operates to define criminal liability, such discomfort must be borne. In the last part of this lecture, I argue that not only should we acknowledge the sharpening of the subjective element of criminal responsibility in South African law and reflect on how this development has manifested in the current legal position, but it's necessary to focus on a further ongoing sharpening of the subjective element of criminal liability. So what would this entail? First, on the element of capacity. Efforts to limit the defense of non-pathological capacity on policy grounds, most clearly demonstrated in the unfortunate Edie judgment, are entirely retrogressive and unwelcome. The mangling of the elements of liability in this judgment and the resultant legal uncertainty which ensued represent a recrudescence of objectivity into what was an entirely subjective inquiry. Some accused will be more affected than others. It's of great concern that a battered woman who kills where there is no imminent threat can no longer rely on a genuine lack of subjective capacity brought about by an act of provocation by the abuser or an erosion of social controls through the severe emotional stress inherent in a cycle of abusive violence. So what defense can the battered woman rely on in those circumstances? If only blameworthiness can properly found a conviction, what is the essence of the argument for narrowing the ambit of the non-pathological incapacity defense to establish liability more easily? Simply that there should be a criminal conviction for what is immoral, intoxication, or socially unacceptable, anger or emotional instability. Pure policy. Similarly, in the context of sentencing, there's never been a debate about intoxication or provocation serving as a mitigating factor in appropriate circumstances where diminished capacity results. By what logic, other than policy concerns, can such factors not provide a full defense? Is this the criminal law we want? Limiting liability to holding an accused responsible when they genuinely have the capacity to control their conduct on the basis of a subjective assessment is the only just approach. The subjective element of criminal liability in South African law needs to be sharpened to deal with the policy-driven damage that Edie has wrought. Writing in the context of English law, where the concept of criminal capacity is not foregrounded, Ashworth comments that the law's concept of intention encompasses many cases of sudden reaction or rage that leave little room for reasoning of the kind presupposed by the subjectivist paradigm. But it is precisely because the accused's capacity is excluded in these circumstances, on a subjective approach, that justice can be done and a defense can be available to a deserving accused. Second, on intention. The subjective element of criminal liability in South Africa should be sharpened by addressing the argument articulated by some writers that only foresight of a qualified, that's real or reasonable or substantial, possibility of harm should give rise to liability. While there's very strong precedent for the approach that simply requires actual subjective foresight of harm for liability, The Supreme Court of Appeal has also stumbled uncertainly into this debate in the 2013 case of Hoctor, where it apparently supports the position that foresight of a real possibility of harm is required. Now, what does real mean? It's surely not being contrasted with unreal. If when the harm occurred, the accused is not acting with subjective awareness of and attentiveness to a real foreseen risk, there's no basis for talking about foresight. Actual subjective foresight of the possibility of harm is required, not some statistical determinant. And if real is used to somehow qualify the level of foresight proven, it is unhelpful and obfuscatory. Again, what would real mean in this context? How would inconsistency between the court's interpretation of what is real be eliminated? It's more practical and less susceptible to injustice to ask, is there actual foresight of the possibility of harm eventuating, accompanied by the accused acting despite such foresight? The degree of foresight is a sentencing matter after liability is established. Ashworth contends that some acting violently may have little appreciation of the extent of the harm or injury they will cause. However, if an accused person does not appreciate the risk being taken from his chosen course of conduct, then he cannot be held responsible for intentionally bringing it about. This is illustrated by the 2015 case of Mauro Hanye, where it was held that the accused, driving under the influence of drugs, had not foreseen that the ensuing fatal collision would occur and were convicted for culpable homicide and not murder. Ashworth, seeking to address difficulties the subjectivist approach may encounter, states that it's surely fairer for the criminal law, in the light of the choices made by the accused to commit the crime in question, to respond as if the defendant had foreseen the foreseeable, unless there is any reason to hold otherwise. To respond as if the defendant had foreseen the foreseeable. Unfortunately, this approach does not assist the subjectivist enterprise, as it introduces objectivity into the equation. To hold that someone had foreseen what can only be proved to be foreseeable amounts to drawing an objectively assessed conclusion. No concession to objective foreseeability is required in respect of the application of the foresight component of dolus eventualis. This point is particularly pertinent in the context of the ongoing challenge of the misleading use of language of objective foreseeability in the context of the discussion of subjective foresight by the courts. Now, criminal cases are typically heard in the magistrates' courts, who are bound by high court precedent. For goodness sake, give them clear precedent. This looseness of terminology, conflating subjective and objective, undermines the subjective enterprise indirectly, even as the judicial reasoning in cases like Edie and Hoctor provide a direct challenge to its application. In closing, a further question needs to be addressed. Are the concepts of subjective criminal liability not undermined because of their colonial and non-African roots, or because they principally developed during apartheid? All our legal rules are susceptible of sharp scrutiny in this regard, not least the criminal law. But some caution is required here. An idea is not responsible for the people who believe in it. Just because the securocrats of the apartheid regime cozied up to common purpose does not in itself invalidate this doctrine. Just because the concept of toerekeningsvatbaarheid and dolus eventualis became foundational parts of our legal system during the height of apartheid does not mean that these notions are doctrinally problematic. While criminal capacity and intention derive from continental antecedents, both have developed into thoroughly South African notions, distinct from their European roots. An intriguing commonality even exists between customary criminal law and general criminal law in respect of dolus eventualis type cases, deriving from sources which long predated the advent of dolus eventualis in the general criminal law. The proper question is whether these concepts are constitutional. And like common purpose, dolus eventualis has been recognized and approved in the Constitutional Court. And so it should be. Even at a time when human rights were being violated on a massive scale in apartheid South Africa, and criminal law was being misappropriated to quell such social unrest, the substantive criminal law being developed through the courts upheld the foundational justification leading to punishment, that it is as autonomous moral agents with an entitlement to freedom of action and the ability to exercise self-determination in their choice of actions that persons are assessed. The right to dignity is the constitutional basis of the principle of blameworthiness. And so consequently, where due to incapacity the individual cannot control her actions, she cannot be held criminally liable. Moreover, if the individual is to be appreciated as a moral being, capable of understanding and choosing, then assigning criminal responsibility entails relating to the accused person with respect, condemning him for choosing to behave as he did, when it is clearly possible to demand or expect of him to behave otherwise. The subjective approach maximizes the choice of individuals about how they wish to organize their lives and enables them to choose whether to risk criminal conviction. Holding someone liable on the basis of dolus eventualis, who has nevertheless acted despite actual foresight of the possibility of harm, is constitutionally sound and the right thing to do. And so my final plea: we need a system of substantive criminal law where only the blameworthy are punished, but where the blameworthy are punished. The subjectivist approach to criminal responsibility based on respect for the capacity or control and intention or choice of the individual is the only just and effective means to properly accommodate both sets of valid due process and crime control concerns in our system of criminal justice. It is accordingly required that the already acute subjective element of criminal liability, first expertly honed right here, be further sharpened. I thank you. Thank you so much. I just want to take a moment to do some acknowledgements before I hand over to the rector. And so I need to first of all acknowledge that I stole the title of this lecture from a piece by Andrew Ashworth. Okay. While I've shamelessly used Ashworth's arguments to leverage my own views in the lecture, I need to say he's on the right side. He is a subjectivist. Actually, this is a good place to start, to acknowledge all those who have spent countless hours wrestling with the same ideas and concepts that animate my thoughts, and who have provided absolutely invaluable wisdom and guidance. The list is too long, but you know who you are. I need to thank all those with whom I agree, and in particular, all those with whom I don't entirely agree. I'm deeply grateful to those who have given me the great gift of intellectual surprise, when through interaction and scholarly conversation, they've helped me advance so much further than I could possibly get on my own. In an academic career, you are always standing on the shoulders of giants, and indeed, I need to acknowledge in particular the intellectual labor of J.C. de Wet, Exton Birchall, Peter Hunt, John Milton, Cully Snyman, and Jonathan Birchall in the area of criminal theory. Cully and Jonathan deserve special mention for their patient and generous engagement and their politeness where I've disagreed with them. And to my collaborators and longtime friends in academia, Marita, PJ, Andre, and Stefan, thank you for the gift of your gracious companionship. I'd like to acknowledge all the students who have had the great pleasure and privilege of teaching and who have taught me so much. That's the wonderful thing about teaching, is how much you learn. Doesn't matter how old you get. Okay. I'd like to acknowledge all my academic colleagues at my previous institutions, UCT, UPE, and UKZN, who have supported me and encouraged me and given me opportunities to grow as a person and as an academic. These are rich gifts indeed. And to my colleagues here at Stellenbosch, unfailingly welcoming, approachable, and thoughtful, who have seamlessly slotted me and all my books and piles of paper into life in the faculty. I'm very grateful. Thanks in particular to all of you who have been so encouraging in the build-up to tonight's lecture. You know who you are. Your support and friendship means a lot to me. I've had wonderful mentors without whom I simply would not be here today. Time does not permit more than the briefest tribute. Solly Lehman's kindness, thoughtfulness, and crystal clarity of thought. Donnie Fisser's friendship, encouragement, and his model of the exemplary academic. Steph van der Merwe's humility, humanity, and cheerleading. And from each of them, the most precious of gifts, time. Time dedicated to my work, to my concerns, to my career plans, to me. I'm deeply, deeply grateful to each of them. And finally, to my family. I know I'm going to do this quickly because, otherwise there may be consequences. To my mum and dad, whose sacrificial love has been my foundation. To Brendan and Diane, for your loving encouragement, and to Brendan for the great gift of helping me never to take myself too seriously. And to Michelle, Kiza, and Ileana, my joy and my delight. It's been quite a journey. God knows and you know. Thank you for everything. And thank you all for being here. Thank you.
Colleagues, distinguished guests, I'm Wim de Villiers. I'm the Rector and Vice Chancellor of Stellenbosch University, and it's really a wonderful privilege to deliver the Rectorate's response to this inaugural lecture. So you may wonder, so my background and my disciplinary background is that of being a specialist physician and a gastroenterologist. So why on earth would I have jumped at the opportunity to be here at this inaugural lecture? This is very, very far removed from my field of expertise. But there is a story here, and that is my father, A.B. de Villiers, Professor A.B. de Villiers, was in this faculty from late 1950s, 58 to 1982, and he was a professor and also an intermittent dean of the Faculty of Law. So the Faculty of Law is very close to my heart. I visited him in his office often and caused havoc. And as I wrote as you can see in the preface that I wrote to the faculty's centenary book, I have very fond memories of this faculty. So the other link is when I looked at your CV, and I saw that you did your PhD or your D Juris at University of Leiden. That's exactly where my dad also did his PhD, but on the subject of mora creditoris, which I had no idea what it was until I looked it up this morning under the law reports, etc., but it seemed pretty interesting. And the other thing that I saw on your CV is that you had obtained a postgraduate diploma in Latin. So if there were two things that my dad loved the law, and he loved teaching, and he loved Roman law, and he loved Latin. So I think what we saw tonight was the passion, and the passion that you also share, and that he had, that we saw that passion coming through, and your love for teaching. And I think that was very, very clear. So because my father was in the faculty for that period of time, and that's the third one. He was, of course, a colleague of J.C. de Wet. So I also knew J.C. de Wet when I grew up. And I can vividly remember at that time, students still had to undergo oral examinations. So my dad taught Roman law and private law, but they had to undergo oral examinations. And I vividly remember students coming to our house here in Stellenbosch and facing J.C. de Wet and my father in oral examinations. And whilst they would await their opportunity or this ordeal, my mom would serve them cookies and tea to try. And the students were all dressed in a suit and tie. Not many females at that time. Now, J.C. had a towering intellect, but also I would say he didn't suffer from false modesty. So there is a legend that J.C. had remarked on occasion that in the history of man, there'd only been 3 great J.C.s. Julius Caesar, Jesus Christ, and J.C. de Wet. I want to just conclude by saying a very well-known academic medical center leader, Joseph Simone, published an article called Simone's Maxims at the end of his career. And it's the 10 commandments that he had experienced, very experienced administrator. I'm not going to give you all 10, but the one important one that I want you to remember is, he said that first-rate leaders appoint first-rate people. Second-rate leaders appoint third-rate people. And I want to really compliment the dean here, Nicholas Smith, as a first-rate dean who in her tenure here has, as was clearly shown tonight, has appointed first-rate academics, of which Shannon Hoctor is a prime example. And I want to congratulate you on that. And it is a pleasure thereby to hand over this certificate to you to really honor this occasion of your professorial endeavor.
Good evening, friends and family of Professor Shannon Hoctor, and good evening, colleagues and students. As Shannon's line manager, as the chair of the Department of Public Law, it is my task to say a few words of thanks tonight. And at the occasion of your inaugural lecture, Shannon, I do so gladly. I would like to thank the Rector and Vice Chancellor, Professor Wim de Villiers, for joining us in celebrating this occasion tonight, and the Dean of the Faculty of Law, Professor Nicholas Smith, for your leadership. It was also highlighted by the Rector. And a big thank you to all those in attendance tonight. I'm really glad to see many colleagues and many students in attendance. For making this special event possible, a big thank you goes to the Corporate Communications and Marketing Division's marketing team, the Corporate Communication and Marketing Division's communications team, the team in the Registrar's Responsibility Center, especially Jonathan Jael Blankenberg, who was the main contact with Professor Hoctor. A special thank you to Yolandi Folander in the Dean's office, who makes sure that all the moving parts ends up in the right location, and to Gerda Adams and Kathleen Adams for their support tonight. A special word of thanks, I think, goes to Professor Hoctor's family and friends that's here tonight, especially Professor Hoctor's wife, 2 daughters, his father, his brother, and sister-in-law, and your continued support for a very dear colleague of ours. And of course, a special thank you must go to Professor Hoctor. Shannon, I don't only want to thank you for the inspiring lecture and for your academic contribution to the department and the faculty, but also for the special colleague that you are in the department and the faculty. Thank you for being a friendly, caring, funny, supportive, engaging, and present colleague. In times when things are gloomy, you do bring a positive and smiley disposition, which is appreciated and valued. And I do think that you plow back what has been given to you by your mentors and those that have assisted you in your journey. So colleagues, as we enjoy the snacks and the wine tonight, let's celebrate Shannon the academic and Shannon the person. And with that, I dismiss you all.
Thank you.